Thank you for tuning into another Better FAQ video series. Today I want to talk about what's the difference between the two types of trademark applications, one called intent to use and one called use in commerce. Now, there are a bunch of different ways and different types of applications to the United States Patent and Trademark Office, the USPTO, but these are the two types of applications that essentially dictate what the process is going to look like for your trademark registration and the entire application. Now, the use in commerce application is the less expensive application, and it is exactly as it sounds. It's the application that you can use when you're using your trademark in commerce. Now, what does that actually mean? I don't have a shirt on today with a logo on it, but if I did and it was a shirt with a Nike swoosh and that Nike swoosh was on a shirt that I bought from Nike, that's use in commerce. That's an easy one. Other things like services, when you're selling those and you want to register a trademark, usually called a service mark, for those services that you're selling, that's a little bit trickier. Usually if it's a service that someone can purchase online on your website, there will need to be the trademark visible on the website with a description of the services and a purchase button or a reservation button or something that actually allows you to do commerce, meaning that your customers or your consumers can click that button and actually then pay for or reserve your services under that trademark in commerce. Now, there's a lot of other ways to demonstrate use in commerce and use a trademark for the specimen that you need to submit to the USPTO, which is part of the use in commerce application. With a use in commerce application to the USPTO, you have to submit specimens, which are just photos typically, showing that use actually in commerce at the time you're filing the application. And if you're alleging a first date of use for your trademark that predates the date of the application, you would need to have that photo, that image, that specimen, that needs to be of something that was in place at that prior date because you are alleging that you've been using the mark in commerce from that prior date, and so your evidence needs to support that. So a couple other examples, on products, you could have a hang tag that has a trademark on it. Also on a website, if you're selling goods instead of services. The purchase button where the trademark is visible with the goods for sale, that's a great example. There are many, many examples because there are many trademark classes, but for a use in commerce application, you need to submit those images with the application initially, and then the process is simplified because the process is then 3 months typically, right off the bat for every application before an examining attorney will review it. And then at that 3-month mark, they already have the images, they have everything they need in order to either approve or ask for more information about your application or reject it. Hopefully that's not the case because you did a trademark search before your application, you've got good chances. But that's the 3 to 4 month mark, and then from there, the trademark will be published for opposition for 30 days, and then after that, it typically registers without issue. So with a use in commerce application, you need to be using the mark in commerce, you need to have images that show that you can file with the USPTO, and then once you do file all of that, it's typically going to be a 3 to 6 month process, pretty smooth sailing unless the USPTO rejects or asks for more information about your application, at which point the lawyer or whoever you had file the application should be able to help educate you and explain to you what that means and what needs to be done to further the application and push it across the finish line. Back now to intent to use, which is also pretty much what it sounds like. An intent to use application is an application that you file with the USPTO demonstrating that you have an intent to use that trademark in commerce at a later date. Now this is different because you don't submit any images at that initial filing, which means that the initial filing is actually a little bit more brief, but the difference being is that once the application gets through that 3-month phase, the examining attorney looks at it at the USPTO, maybe they ask for information, maybe they reject it, similar to a use in commerce, but then it will be published for that 30-day period of time, and at that point, you're required within a 6-month window of time to file those images showing the mark being used in commerce. And again, examples that I provided before, Nike swoosh on some products, hang tag, website for purchase, reservation, those are all good examples, but that would come at around the 4 or 5 month mark of the intent to use application. And then if those images are acceptable, the application will move on to registration from there. Now, the kicker with the intent to use application is that there is an additional filing fee for filing those images at that later date. It's typically $125 per class. So if you have a multi-class application, it can be a little bit pricey. And so that's where the use in commerce is typically less expensive because there's no additional filing fees as opposed to the use in commerce, or the intent to use rather. And the other thing about the intent to use application that's worth mentioning is that I've had a lot of clients over the years where we file the intent to use, they have every intention and plan to use that mark within the next 6 months or maybe 12 months, because if it's a 5-month process and then a 6-month window, you got about 11 or 12 months depending on how quick the USPTO moves. But let's say then something happens and then there isn't the ability to actually show the mark being used in commerce during that period of time, that 6-month window. You can file extensions. The USPTO allows for 5 extensions of 6 months each. Now, those also have a filing fee per class, which is typically $100 per class to extend for that 6-month period. And that would be each time you extend, so you can see where that can get pricey. And once you've exhausted the 5 extensions, that's it, that's all, folks. Then you're out of room for extending and you need to file those images before that. But you could see, 5-6-month periods of time is a few years. So you have time if you need to, and if you have the money to pay for the extensions. Now, before I wrap this video, I do want to talk about what's the purpose then of filing the intent to use application. If it's more expensive, potentially longer, I've got to deal with my lawyer again, who wants to do that? Well, the intent to use application is a valuable application if your trademark is one that you anticipate might be something that becomes popular and other people might start using it or might try to apply to register it instead of you. Because the intent to use application, its real value is that when you file that application, you might remember when I said the use in commerce application, you actually tell the USPTO, hey, the first date I ever used this trademark was January 5th, 2014, as an example. And you get to tell them that and then demonstrate that you had something in place then to show them that that's true. With intent to use, there is no, hey, I used it as early as this date, because it's an intent to use. You have not used it yet. So the priority date, the date where your rights then attach, assuming you do get approved for your trademark registration, the date that that registration retroactively gives you rights from, your priority date, is the date you filed that intent to use application, which can be very, very important if, it's 11 months later, 2 years later that you actually file the images. You'll actually have rights all the way back to that date that you filed the application, even though you filed the images and started using the mark much later. So it's a very valuable thing if you want to protect that mark that you know you're going to use, but you're not yet using. And of course, if you have that extra money to pay for the extra fees or the extensions. So, intent to use versus use in commerce, they are different, they have different fees, and they have different value depending on what you're looking for as far as protecting your trademark. Hope this was helpful. Hope you tune in again. Thanks.